Welcome to Laid Back Law with your favorite lawyers from around the interwebs, discussing the most pressing of topics every Friday at noon Eastern Time.
All right, we are here with a much shorter intro. Kind of had to redo things a little bit on the beginning, but we never know who's showing up, so it's kind of hard to get everybody in anyway. It's a free-for-all. I've even thought about using silhouettes for all of my thumbnails. It'd be like a jury box of question marks, who's going to be here. But today we've got a nice lineup. Again, we got Ian Corzine is back. Norm Pattis. Ian's coming to us from California, I guess. He's on the road.
The land of crazy laws.
Yes, and apparently not fire hydrants. I guess that's the latest thing is robbing. Now, get this straight. They're stealing fire hydrants to sell for the metal. But what I love is they steal cars to ram the fire hydrant and knock them off. And instead of just selling off the stolen car or, going to a good old fashioned chop shop, no. We use the car as a tool to get the fire hydrant. California, just keep on keeping on. You're giving content till the end of time, I think.
That's the best part about it. I cry.
Norm, how are you doing, man?
Hanging in. Lost a murder case last week. So, mourning that and getting ready for another trial next week. So, living the dream.
Living the dream. Yeah, that's got to be rough. Kurt, what's happening?
Hey, what's up? Just a lot of Karen Reed insanity and just, keeping on. Life is good. Channel's been doing well. It's been nice.
Well, that's always a good thing. And Danny, welcome back. Good to see you.
Thank you. I'm still adjusting to the time change. I haven't slept in about 24 hours, but we are going to be catching up with Karen Reed coming up this next week. And I also want to talk about the serial killer. This is getting crazier. Have you heard about the family members who came out or one of the victims' attorneys came out and said something about the daughter somehow being involved?
Rex Hewerman, the Gigolo Beach one?
Yep.
I saw something about the kids are sticking by him and that the family got paid a few $1 million for rights to their story, which there's some talk about changing the laws in New York to not allow family to sell it, same as a perpetrator, which doesn't seem fair to me personally. If you happen to be married or have a father who's a serial killer, most people wouldn't, choose that to happen, and their lives are already affected. So if they can sell off their story, then is that necessarily evil? I'm curious to get your guys' thoughts on that one.
Yeah, I'm not sure how that would work because the principal idea, for the murderer is essentially criminal asset forfeiture. It's a fundamental concept, right? It's like not that you can't publish it, you still have freedom of speech. It's just we're going to take the money,
sure,
because it's a forfeiture as a result of your criminal conviction. So I don't know how that logic applies to people that aren't even criminally implicated just because they happen to be family. So I don't know how that works legally. I don't think it does.
I think they've got First Amendment rights to tell their story, and I think Son of Sam laws in general have not fared well in the courts. I can understand asset forfeiture, as the proceeds of a crime. But if you commit a crime and then write about it, is that the proceeds of the crime? And should that be prohibited on First Amendment grounds?
It works for me, but maybe we could have a disagreement.
It's
a derivative of the crime, but for the crime, you wouldn't be able to write the book. So it's a derivative of your criminal acts. So why not?
Well, the criminal acts of someone you're related to.
Yes. Well, in the case of a family member,
so the family member should be able to absolutely sell their rights.
I agree.
And come and do TV interviews. Is it distasteful? Absolutely. But at this point in time, the guy's not convicted. But they did. I've read through some of the most recently filed documents. They came across a kill kit how-to, a little checklist of things that he needed in order to carry out these murders. Allegedly.
So he's organized. He is not a disorganized. He isn't organized. Killer.
And one of the new victims they
wants to publish his how-to manual, I'm sure people will be very interested.
Oh yeah, I'm sure they would be. I don't know, but I don't know that much about the case. But let's go and pivot about somebody most of us have heard of. was found guilty this week. It's the first time in history a president's son has been found guilty of a felony, apparently. And Ian, you've been covering the Hunter Biden case. Any thoughts about it? Whatever?
Well, I covered a kind of different angle because we don't really know what the situation is with the sentence. There's been lots of different lawyers have told stories about, everything from probation to 10 years in prison. Really what I thought was interesting is the case seized upon the definition of, or the law that applies with respect to applying for the purchase of a gun. And, while we've always kind of focused on, you can't use a gun when you're inebriated in some way, and that could be alcohol, it could be weed, it could be harder drugs. This case really focused on use. And so what you have to do is you have to promise that when you buy this firearm that you are not a user of a controlled substance, and it actually labels marijuana and some other different drugs. And so one of the things that, the reason why Hunter Biden got convicted was because they were able to prove beyond a reasonable doubt that he was a user at the time of the purchase of the firearm. And my video just took kind of the approach that, wow, well, that's quite broad. Does that affect our Second Amendment rights? Plenty of people who are famous out there. I talked about Joe Rogan and Miley Cyrus and people like that who are known marijuana users and frankly, arguably legal users because of the fact that state law allows, personal use of marijuana, and they have guns. They're known to have guns, and not only could they say that they're regular users, but what about the type? Like I just used an example of myself. What if I use marijuana 3 days ago? I don't, usually use it, but I used it 3 days ago, and then I want to go in and buy a gun. Am I technically a user? Because I've used it at some point in time, anytime legally. And if that's the case, then it really does curtail our right to own guns. And the other part is if we're in the society where we do lawfare, the next person who speaks out of turn, so to speak, could be brought up on federal charges because that person was a user of, let's just say, marijuana at the time of the gun purchase. So there's a lot of, interesting issues that have to be ironed out with the ATF. That brings us to our discussion about the Supreme Court decision today too. So we'll talk about that later.
I agree. I question if that law is really constitutional. It doesn't make sense to me. And okay, so maybe he doesn't use drugs. Maybe he's a raving drunk. Maybe he drinks 24 hours a day. He's always drunk. Oh no, that's fine, right? They don't mention alcohol. You could be drunk, whatever. Go buy away. It just seems kind of arbitrary. Plus, do you know for a fact that he used immediately before he bought it? Was he high when he bought that? Did you do a pill test? Did you take his blood? Do you have any idea if that actually is true? I'm not a fan of Hunter Biden, and it's not because of his drug use. I actually feel terrible about his addiction, and I feel bad for anybody with an addiction. I don't like him because of corruption that took place, in my opinion, recorded by the laptop. So I did want to separate those two components. But as somebody who doesn't like him, I think this case is kind of bullshit. In my opinion.
I think it's bullshit, but let's not pretend that these cases don't exist and that prosecutors don't pursue them against lesser known individuals.
Of course they do.
All the time. I mean, essentially, he lied on a federal document, and that's what it boils down to. Yeah. And people get prosecuted.
This count is a tack on charge. This is a tack on charge. Like this count is tacked on all the time. Like unlawful possession of a firearm. They put the lying on the federal form. And color me shocked that there's something in the federal code that's arbitrary and not well defined.
I think the ATF once took the position that any use within a year, any use qualified under the statute.
Correct.
So if you used that drug 364 days ago, that would qualify you as an unlawful user under the statute, at least according to the DEA or the ATF, whichever one.
That's the other part to it is, does the ATF have this, in my opinion, legislative authority? They're creating these regulations. And again, it brings us into our bump stocks discussion. And then they really impact the Second Amendment, which is just an amendment we hold dearly. So
they do. And it's terrifying that they do. That's what's scary. And hopefully with recent Supreme Court decisions and cases that are hopefully coming out, that will that will be changed.
I'll tell you what, my friends, if this conviction stands and Hunter Biden winds up being the one that takes it all the way to the Supreme Court, and the Supreme Court says it's not constitutional, and Hunter Biden is the one that got us further gun rights, I will laugh endlessly at the irony.
Oh, yeah. But isn't that the way it works? I mean, normally the people who get changes or laws overturned aren't nice people. I mean, if I recall, Miranda wasn't a very nice guy.
No, he wasn't.
So
a little stab friendly.
Norm would agree that sometimes it's the worst people who get the laws changed.
No, the point being that the legacy of the Bidens is broadening Second Amendment rights, and that's like the best legacy of the Bidens.
Oh,
that
it would be sweet.
That's
Sweet,
amazing.
juicy irony.
Yeah.
We could give him awards at NRA conferences. We'll give him a trophy. It'll be great.
Well, think of his name. There's actually a term for it, but his name is Hunter.
Yeah.
That's true.
Too bad it doesn't also go towards legalization and getting rid of mandatory minimums.
Well, that's already, I think, happening all over the place, isn't it? They just rescheduled marijuana and other. So it's pretty much being erased. Also, a lot of people have been talking about the whole deal of how many people are locked up for just a basic possession weed crime federally. I think when they went through the numbers, the number is very low, a lot fewer than you would realize. And some of these people were not just, caught with a joint federally or a little baggie full. They were actually distributors who pled down a lower deal in what they were doing. So again, I think a lot of the low-level people have already been freed or let out, but you guys can correct me on that.
No, that's very true. Like Rob was saying, it's a tag-on charge typically. I just wonder if the law is not changed, if it will now be used as a sword and a weapon to motivate people either to recant or to, roll over on different other crimes. Will it be, something they use to attack personalities to quiet them? So that's the only thought I had for it. I have no idea what the sentence is going to be. I think it's going to be light.
Yeah. But I tried to do the math myself. I came up with 14 to 48 is what I got on my calculations. So, which presumably would be all suspended in favor of probation. So you're looking at essentially no time. So that's what I came up with on the math.
How did you get that?
I went through a sentencing calculator and tried to figure out the appropriate sentence.
Usually the guidelines are like 8 to 10 months, but I mean, I get it. I didn't pay a lot of attention to the trial. I thought that the question wasn't use so much as addiction. And given his florid crack addiction at the time, the conviction didn't surprise me. But I may not have been paying attention.
My partner on America's Mental Stories, Mark Grobert, had an interesting take, though, because he's a drug counselor and he deals a lot with this in real life, cases. And as he put it, Joe Biden is doing something that a lot of parents actually do. When their kid gets convicted, they deliberately are happy for the conviction because now their son is on probation and has to report in all the time. So they know that there's going to be some more regular testing to help keep them off. I'm just telling you that,
Eric, but this is not a normal case. Yeah,
of course, it's not a normal case, but
typical situation where, Hunter is reporting to his probation officer. I mean, probation officer is probably getting him drugs.
Allegedly. Anyway, I'm just telling you what he said. It does make sense that there are parents out there who do that in the system. I mean, Robert Downey Jr. has stated outright, if he didn't go to prison, he'd be dead. That allowed him to kick. So it's not always a terrible thing.
Well, his father thinks he's the smartest person he's ever met. So I don't know if that counts.
Well, does his father remember who he met 2 weeks ago?
Did it say that? I'm just quoting the man.
So, I mean, if he's living a memento life, that could be true. Just saying. All right, so let's shift to, I've got some super chats here. Where's Phil? He's been banging out YSL. Phil's big time, and he goes on Fox News. So I think he's doing Fox News today, and maybe he'll jump in later. Don't know, but hopefully. That's part of the reason I'm not talking about the judge now, is hoping that Phil might come in too, since he's a local there. Jordan L. this may be old news, but can someone explain to me what the baldo is? And it's about Ricada. The chat has answered this question pretty well. I'm not going to go into the implementation of tools and toys. Kimmy Joe, Kodak Black spent 3 years in prison for the same crime that Hunter was found guilty of. Okay, again, I don't like the law. I think the law is bad. I don't like Hunter. I don't like the law. Two things can be true at once. Andrew Ho, just remember that this case for Biden came about when the sweetheart deal, yes, was outed. This was the show trial. He still has a tax evasion case coming. The one good thing is the laptop was proven to be real. Yeah, the real charges that everybody cared about, the corruption charges, all of that just vanished.
Which now also means that for the tax charge, now he has a higher criminal history score, which means for those charges, he'll get extra time when he's inevitably convicted. Because I looked at the indictment and they've got it.
All right. Will there be testing Joe Biden for drugs? I'd love to before the debate. I would love to see if there's any traces of Adderall or any substance, even though Trump's been known to take Adderall from what I hear too. So I don't know. Let's shift to Supreme Court decision this morning. Which of you covered that? Bump stocks.
Yeah, well, I was reading it today. So the Supreme Court 6-3 ruled that the ATF's attempt to ban bump stock by pure regulation was not compatible with the statute. This is essentially a matter of statutory interpretation rather than Second Amendment. This goes back to the machine gun bans relating to the gun control acts that have been passed by Congress, and just defines basically an automatic weapon as any weapon that allows for the discharge of essentially more than one round by a single pull of the trigger, or what function of the trigger, I believe, to use the exact language. And so it just basically came down to the fact that a bump stock does not do that because it still requires more than one function of the trigger. The trigger still has to reset and be pushed back. Now you're using a device that helps to facilitate that by using the recoil force to help drive the recoil force into the trigger to cause that to happen. But still the trigger has to individually operate for every individual round. And so therefore the bump stock does not operate as a machine gun because it doesn't change the function of the trigger, was essentially what it came down to. This is because it's criminal law, Chevron does not apply. So it's just and also a rule of lenity. We're trying to interpret it in favor of the defendant because it's criminal in its nature. And so you kind of put all those together, and this is kind of what I thought it would be. I haven't read the dissent, but I read the Cliff Notes version, where apparently Sada Sotomayor was angry because apparently bump stocks walk like a duck and talk like a duck, and therefore it's a machine gun. So that was apparently Sada Sotomayor's analysis, and that's where we're at.
So she was on the dissent side.
Of course she was.
Come on, Joe.
What do you think? No, she wrote the majority opinion, Joe.
You didn't break down how the 6-3 went. It really could have went anyway.
Yeah, I think we can figure it out.
I mean, I just read a snapshot of it, but Alito came through and was basically saying, hey, Congress has this really cool power. It's called writing laws.
That's right.
And during the entire pendency of all of this, it could have been really, really easily done with a quick write of the pen. You want to clarify what this thing is meant to be? There's a whole lot of political movement around it. Just amend the law. It's not hard.
I think Rob is entirely right. That's what I drew from this. This is actually a victory for democracy. I don't care if you like bump stocks or not. I've watched the videos. They are unbelievably powerful. There's no question about it. But the point of this whole opinion was not to get into the statutory interpretation. What is a machine gun? What is not? It's basically saying, F you, Congress, do whatever the hell you want to do. Do your job. If the people don't want bump stocks, then pass a freaking law. We're not going to do that for you. And I just thought this was a great thing. And you could, again, like I said, you can hate bump stocks all you like. But if they were to get in and the Supreme Court get in and legislate on this and say, oh, no, actually, we're just going to amend the interpretation of machine gun to be able to include bump stocks, then we're, again, usurping the role of a unique branch of government. So my thought was everybody should jump up in joy. Finally, the Supreme Court is just saying, dude, we interpret the laws, executive enforces the laws, legislative creates the laws. Let's just continue on this route.
Do you guys think that there can be an argument made by the Second Amendment advocates that machine guns banning of machine guns in general is inconsistent with Bruin, and as far as
not with Bruin,
the history and context? Do you think that goes back in history and context? I mean, I guess the machine guns have been banned for so long that perhaps it can be considered part of
Joe,
that.
it's easy to make the legislative record to hold up to that constitutional scrutiny, man. And that's the thing. It's not so much about whether you can or cannot regulate it. It's what record you have to have in the legislature to overcome that burden and scrutiny that's placed on that being a core fundamental right. You're talking about a machine gun, you're talking about a very different legislative record than you are talking about a handgun or a single action firearm. I mean, it's just a different thing. It's a different animal.
I didn't realize Chevron didn't apply in criminal cases much. So thank you for that. I'm still stunned at that gap in my knowledge. So I'm several paragraphs behind.
Chevron may not apply in any case if the rest of this term is kind to us, but we'll see.
Yeah.
Well, this is good news, though. It is a step in the right direction. If following on Ian's comment, this is putting the power back in Congress, and hopefully with the abolishment of Chevron, we'll see the same thing.
What about regulatory offenses that don't necessarily carry imprisonment, but just a fine? Would that same analysis apply?
No. As long as it's not criminal, exposure, Chevron would still apply. So if it's just
and what does criminal exposure mean? I mean, imprisonment or fine?
Yeah, imprisonment.
Yeah, and only imprisonment. So that
it would be any criminal.
I mean, the criminal code typically gets divided into three things: felonies, a year up to death, misdemeanors up to a year, and then infractions, which are fines. And an infraction is part of the criminal code. And so I'm wondering, if it's a regulatory offense, wouldn't that same analysis apply? And boy, wouldn't that just be kaboom? Maybe that issue hasn't been raised. I just don't know.
But Norm, would it apply? Because didn't you say, Kurt, that the court found that they were trying to interpret outside of their statute? So wouldn't it not apply? Because you don't even get past the first step. They're not interpreting something within their wheelhouse. This is something that is a separate statute altogether that they went out and misinterpreted. Is that right?
I hear you. I'm just going back to the general Chevron point, trying to get a general education here. Yeah.
Well, you might be pushing me on my limits on that one. I know the broad rule, right? It's like criminal if it's criminal because Chevron doesn't apply because, rule of lenity and other principles usurp the idea. But yeah, with this case, you're talking about the Gun Control Act in 1930, which by its own terms has criminal penalties for its violations. So it's pretty kind of on point. You don't have to figure out whether it's criminal or not. It kind of says so right on the label. So.
Well, I mean, the other thing to remember in this case is that from what I understand, this was a situation where the gun owner with the bump stock surrendered the weapons to the ATF, and it was under protest. So this is just like a declaratory relief action.
Yeah, kind of, sort of, yeah.
All right, interesting. Let's go ahead and shift. I think everybody has been following, at least to some degree, the Young Thug trial now. Which
how many years has it gone?
Day 91 in trial, I think, is where we're at, and I don't think that includes the actual seating of the jury.
Yes, it is mind-boggling everything that's going on there, and actually, I'm getting the wrong copy here.
We should judge this trial based on how many motions for mistrial we get. I think we've got to be up to a couple hundred by now.
Well, I think it could be argued that they're legit.
And how many trials in the future? Because if there's a conviction, there's going to be a reversal, and so we're at it again.
That's what I was talking about this the other day. Just going, what's the point of going forward in this trial? It's going to be there's never going to be a resolution. Not during any of our lifetimes.
Well, here's
how long is it forecast to go? Do we have any idea?
They said the testimony won't be closed this year.
2025, just on these defendants. There are additional defendants that will be tried, and the threat was not, just to correct the record here, the threat by the prosecution allegedly in this ex parte communication was not that they were going to hold the witness until the end of this trial, but until the end of all of the defendants' trials, because he's a key witness in all of them. And so we're looking not, till 2025, we're looking decades out.
And did they really immunize? Somebody told perjury prospectively
they quasi immunized him. They immunized him.
I mean, I never heard of that. Yeah,
they immunized him, and then they said, but if you testify inconsistently, you're no longer immune. And by the way, we view this to be inconsistent. Like they gave a very narrow interpretation
if he would
of
said
what
that
he was allowed to testify to.
Yeah, that if he was going to lie and claim that he was the one who offed Donovan, in that case, they were going to then they'd go after him for perjury, which is
otherwise
he was lying.
No, it's not. I'm with Danny on this one. Like, it's not.
Is it clear he was even lying?
It's a joke. Eric, before you play the video, do you have the affidavit? Because I have that. If you don't have it.
Go ahead and send it or whatever. But no, this is one clip. This is just most recent.
And make your record. Or anyway, this is a record. This is important. Okay, but it's your allegation and assertion, sir. Okay, so well, we don't know that. We don't know whether or not they're true. Going on every time Mr. Copeland comes in the courtroom or out of court, he's escorted by a DA's office investigator. You see that? This court is observant. You're not just sitting there in a cloud. You see exactly what's going on. You hear the prosecutor tell you, we were in a room with Mr. Copeland and he said these things. Why? Okay. Why do I have to bring up? You should be bringing up. This is crazy. This is like communist Russia.
Wow.
That's a little strong.
Not wrong.
So I am moving again to stop intimidating the witness by the prosecution, leave people alone, and stop accusing. You've allowed the prosecutor Love to accuse me of misconduct. Oh, but you've also accused her of conduct, so you can go ahead.
Anyway, so as you can see, things are not calming down between Steele and the judge. That was yesterday.
Okay.
There's no way he's staying on this case. That's not possible. I mean, that's
Eric,
just
there's the affidavit. Sorry.
That's
in the private chat, or where did you go?
I shared screen.
Oh, sorry. Hang on.
Do you guys think this case is salvageable? Like if they were to, if he was recused?
There's so many appealable issues.
This is such a freaking mess right now. So this is the affidavit that accompanied the motion to recuse, and I mean I kind of played around with the highlighting, but Glanville instructed the witness and all parties. So again, we don't have the transcripts yet. These are being held back. I see no reason why we're not getting the transcripts. It's complete BS. But basically says Copeland's going to be jailed to return to court. That was on June 7th, so he gets held over for the weekend. Then everyone's present at 9 because Judge says, hey, we're going to be here at 8:30. But Judge was not there. Judge was back in chambers meeting ex parte with Ural, Glanville, DA Love, ADA Hilton, so both members of the prosecution, other members of the DA's office, deputies, the sworn witness Copeland and Copeland's stand-in counsel. It wasn't his normal attorney, it was the stand-in attorney. So no one present. Between 11 and 11:30, the judge takes the bench and announces that he's going to testify. Steele then says, hey Judge, where were you? We were supposed to be here at 9. You weren't here. Prosecutors weren't here and the witness wasn't here. So kind of wondering what's going on. Judge doesn't answer that. But they later discover that in the ex parte meeting, Copeland says, I'm going to take the fifth. And then says, I'll happily sit in jail for 2 years rather than testify. Glanville then tells Copeland that he can keep him incarcerated until additional defendants are tried, not just the 6 defendants currently on trial, which that's a problem. Then the ADAs chime in. So now you have the ADAs making statements, judge making statements to the witness, without the jury, without the defense present. Glanville, where was it there? So they says that he will testify, blah, blah, blah. Glanville then prints out the perjury statute and false statement statute and hands it over to Copeland. Are you kidding me?
Is Copeland got advised by counsel at this point? Is he alone?
Yeah, Copeland's got stand-in counsel. So Copeland had a regular attorney. That attorney couldn't be present at this particular day.
Is that the one you said she fired? From
the stand?
Is that the one?
I think that's
the normal one. But this attorney is here witnessing this, doesn't have a history with Copeland, doesn't know what's going on in this case, and is basically just getting ambushed with this. And I can completely see why this attorney would then immediately go out and tell the defense attorneys. I think I would have an ethical obligation to do that.
Yes.
And I don't think a judge can stop me from doing that. My law license versus a judge telling me, no, don't do this.
Yeah.
But this is just ridiculous. And then he says he's going to go ahead and, what is it? Chief Judge Glanville Copeland says to Hilton that he's going to say he killed Donovan Thomas. So there's Brady material that's being discussed in an ex parte communication that's not been disclosed. Then you've got, what is it? The ADA telling Copeland that she's going to prosecute him for perjury if he testifies that he killed Thomas. So not just Brady material, but you have Brady material, which is this individual's statement that he killed this other person, Thomas. And now you have the DA not just not giving it over, but saying that they're actively going to prosecute against it. I mean, if half of this is true.
Does Georgia
I don't give a shit what was even said. The fact that it was said without notifying defense counsel, at least putting them on notice, is the issue here. Fundamentally, that's the issue right there. It doesn't matter really what was said in privacy in chambers. Notice should have been given to the defendants. They all had the right to that.
Does Georgia not have an emergency public interest appeal statute? I mean, in Connecticut, if you're in which is where I practice for the most part, if you're in a proceeding and something goes fundamentally haywire, I mean, like this, you have a right to ask for an immediate public interest appeal. You write a letter to the Chief Justice of the Supreme Court, who must answer you within 10 days. And so, this in and of itself would have me asking for an immediate public interest appeal. What in the hell's going on here?
Norm, it gets so much worse than you even think. It gets so much worse.
Apparently. The
judge issues a show cause rule without a named defendant, no named respondent. So he issues a show cause rule to whomever has knowledge of this. So facially flawed, can't go forward. Yeah, seriously.
What do you mean? Everyone who attended the meeting is required to appear on June 25th. Everyone
show cause
under threat of being held in contempt.
I thought that included all the defendants who raised their hand and asked for a mistrial because they are now also all aware of the information in the ex parte communication. That's how I read that order to show cause.
It includes everyone who has knowledge of that.
Right.
Are we supposed to appear?
I don't know.
I saw it on court TV, Judge. What do you want me to do? Yeah. Who are these people?
The judge would probably try to hold us in contempt. He'd probably do whatever he could. It's just ridiculous.
It's astonishing how. What's so strange about this is this judge apparently has a reputation in Fulton County for prior to a week ago, having a pretty good reputation.
Yeah, lead attorney said he's an okay guy, I think.
Yeah, and we're watching him just completely melt down over this issue in ways that are astonishing. It's not like it's someone you expected from, apparently. It's someone who was otherwise a respected judge, and just one decision after another. When he was faced with this motion that Lumber just brought up here, when he was faced with it, he denied the motion and he cited a case named Baptiste. And his logic and the Baptiste case, which I haven't had a chance to go through it yet, I only saw it late last night. But the Baptiste case, apparently, based on the rule of law he was drawing from Baptiste, is that you cannot move for a recusal based on the fact that you do not like a decision from the judge. And to try and say that that's applicable here in this scenario is ridiculous, because clearly this has nothing to do. And he says, well, in part, you're upset about the fact that I didn't recuse myself when that motion was made before me on June 10th by Brian Steele. And it's like, no, that's got nothing to do with that. If you never made a decision on that or anything of that nature, that's completely irrelevant. It's this whole litany of facts that he just attested to in his affidavit, which make your entire conduct in this thoroughly outrageous and displaying unreasonable bias. That's why this is being brought here. And if you had never made that decision, they still would be bringing this. It's got nothing to do with his denial of recusal, but he's just trying to find some way to shoehorn in case law that helps him. And he did that. He did that even with the contempt motion, right? He tried to shoehorn language in. Was it criminal contempt? Was it civil contempt? And he tried to shoehorn language in to try and backfill legal justification for decisions that clearly were rooted in other bases
Joe,
at the time that he's making them.
Well, while you're saying that, can you guys go really quickly as the non-lawyer? Can you go over the differences between the civil contempt and the criminal contempt, which I think is very relevant to the conversation for people to learn about?
Yeah, the civil. But before we jump to that one, I think the judge also did something that demands recusal. This was a sworn witness, which means everything that this person's testifying to on the record, which it's an ex parte proceeding, it's still on the record, is being sworn to. This judge just heard this witness say that he killed this other person. He was present for that. He's a witness of these proceedings. He's a witness of Brady material. He made himself a witness in this case. I don't think he can go forward and continue to issue rulings on this case. And I can't fathom a world where at this juncture he can preside over this motion to recuse.
Whoa, is this true?
Well,
the attorney said that he has an emotional support dog in court with him.
Okay, to be fair, this is a circus of a case. I probably won't want to. But you asked the difference between civil and criminal contempt. Yeah. Ultimately, what it boils down to is sort of the punishment, right? So civil contempt, the only way to purge it is you do what the judge has asked you to do. Criminal contempt, the punishment is you either get jail time or a fine or both. And that's how you purge your contempt. So there are two different ways of handling it. What the judge was asking for was civil contempt. If there's a civil contempt issue, then he doesn't need to go down the litany of rights and host a hearing and have notice and everything else that goes with criminal contempt. But because he was saying, no, I'm going to say right now that this is criminal contempt, even though that clearly was not his intent until Ashley Merchant explained to him the differences between civil and criminal contempt. And then he took, an 8-hour break to come back, or however long it was, then come back and say, actually, no, it is criminal and it's immediate. And that's my ruling. Once he read through all of her cases and the way she laid it out and was able to circle that square. So I love this case.
A judge can't make a uniform a finding of criminal contempt. You can't do that.
Well, he says he can, and that's why this is going up to Supreme Court.
In Georgia, he can. He can do direct criminal contempt finding.
All right.
Yeah.
Georgia's weird. Why not? Let's throw that on the list. Sure.
Let me tell you guys about one of the weirdest experiences I had in federal court and see if this sheds any light on the analysis here. A witness, a client in a multiple defendant case, he was going to plead and he was going to get the benefit of a cooperation agreement. But as is always the case, you want to keep the cooperation agreements quiet until the last possible minute. So we're summoned into the judge's chambers. It's just me, my client, the prosecution, a court reporter, and the judge. And the guy goes through the elements of the cooperation agreement with the judge, and with the prosecution makes its recitation. There are some questions asked. And then the judge says to the guy, we're going to go out onto the record and you're going to enter your guilty plea. And when I ask you whether anybody's made any additional promises to you, you are to say no. And then we marched back out onto the record, and the client lied as instructed by the court. So when I heard about the meeting in the chambers here, I thought, what's going on? We have a reluctant witness. He's being offered something like immunity. I don't know what the Georgia immunity statute requires, what sort of showing, what sort of hearing. Are there ex parte immunity hearings required in order for a court to grant immunity in Georgia? And if so, does that change the analysis here? Does anybody know?
My understanding is that Georgia doesn't have any exception for ex parte communications with a witness, especially not when they've already been sworn. Well, that's a big turning point. And the only time it ever comes up is when there's a risk of actual harm to the witness by one of the defendants, and that there would be a good faith reason to bar that defendant from hearing what is going on or getting knowledge about what's going on in this discussion, because it might be talking about witness accommodation, where the witness is staying, security, etc. But even then, the counsel is notified and at least advised of what transpired in that meeting immediately thereafter.
As opposed to here, where he not only did the judge fail to advise the defense counsel about what happened, but he's trying to have anyone who told them anything about what happened held in contempt. And conduct this entire witch hunt investigation that he's now sua sponte, bringing his own order to show cause. It's astonishing. That which he's trying to figure out where the leak was is precise, and he's calling proprietary information, is something that he was duty bound himself to tell defense counsel. That's what's so mind blowing about where he's coming from here from my end.
I think it's good. There's good money to be made on a T-shirt for judge proprietary information. That was a pretty funny line. You know what? Has the press in Georgia gotten wound up about this? Because I've always thought that the First Amendment right of access to the court meant right of access to where the information takes, where the business of the court gets done. Connecticut, we do in state court, we do 99% of our work on pleas, at least in ex parte, in public, non-public communications in chambers. We rehearse everything, we come out, we say our lines, and the public never really gets to see the sausage get made. Has anybody from the Georgia Press Association sought to challenge this, or asked what if there was a transcript made, asked for a copy of the transcript and tried to make a First Amendment issue?
There is a transcript. The judge has slow walked the fact that there is a transcript, and the defense counsel keep making motions for the transcript. So
the press get involved too.
We know that it exists, but as far as the press and the access to this courtroom, I've never seen anything more restrictive. The judge kicks cameras out of this courtroom more than you could ever imagine. The camera's not allowed in the courtroom.
Oh, why, Rob? Why would he do that?
You ask. Oh, I'm done. I hate this case.
My favorite part of it is the obvious bias where the other attorney stands up and says, look, I obtained this information the exact same way from the same source. Why aren't you throwing me in jail? The judge goes, because I didn't ask you.
Well, that was a pretty slick little duck on that, because the judge was already screwed, from what I understand, in some ways, by if he sent the whole legal team, then the case stops, right? I mean, there has to be somebody there. It was already shaky. By sending
the case just needs to stop. I mean,
he did a take back.
Supreme Court, I was involved in a case once that lasted 88 days. That was a Proud Boys case. That was like 44 days too long. The fact that we're at day 91 with no end in sight, that's almost cruel and unusual punishment, as it were, to jurors. And it suggests a prosecution that's wildly out of focus and doesn't have a coherent theory of the case.
You ever heard of Bonnie Willis?
They spent 10 months seating the jury.
Yeah,
it took them 10 months to seat the jury. That tells you right there. And by the way, and to a very large degree, this is not on Judge Glanville. As much as he looks like a clown this past week, this is not as much on Judge Glanville as it is on the prosecution. Prosecution made this such a clusterfart of a case, so complex, so completely it turned this into a 40,000-pound gorilla that it was almost inevitable that there's going to be some major foul up along the way, which would lead toward a judge desperately trying to cover his tracks or at risk of there being some sort of mistrial. Now, the nature of the foul up that happened here, frankly, was particularly egregious when he's bringing in a sworn witness into his private chambers and sitting there while a DA is breaching every code of ethics you would imagine a DA is sworn to uphold. But at the same time, the DA, by not breaking this up into different defendants, has made this such a massive animal that it's almost inevitable when you're going through something for 2 years, 3 years. I mean, that's how long this trial is supposed to take: a year of seating and 2 years of trial. It's insane the way they handle this, and it just shows the utter incompetence of the Fulton County DA. I forget who the DA is over there, but
Fonnie Willis. Fonnie Willis. Anyway, I wonder why, right?
The expert at RICO cases.
Yes. And that's what this is. I love it so much. Everything about this case I love. And unfortunately, the smartest juror there was the one who actually did the filming of everything going on, because that juror got out of jury duty. Well, everyone else is stuck there.
No, I'm being very serious on this, because if I got put on a jury like this, it would destroy my life. I wouldn't be able to stream. I mean, it would cause me permanent hardship. And many, many, many people, I believe, are in that boat. Don't give me that $25 a day bullshit. Unless somebody's working for a corporation where the corporation has part of the contract that they'll cover their wages, this is harmful. And it is not right to subject people, I feel, to this kind of trial. So I'm asking all of you, what kind of recourse do normal citizens, like me, I'm willing to participate to a point in a system, but it's a jury participation, not an enlistment. I enlisted in the Army.
The answer is you tell the judge it would be financial hardship, that you can't do it, and they'll let you out. I've never seen a judge not let out somebody who said it would be a financial hardship. He did?
This judge has seating the jury was impossible. Isn't Glanville the one that held one of them in contempt and jailed him?
Yes, that's exactly what I'm talking about. One of the jurors was filming. Another juror tried to get out of jury duty after the fact and said, "Oh, sorry, I have this trip, so I'm going on my trip," and just didn't show up. And then they were forced to write an essay. And then one of the defense counsel has already said that they are going broke, that they cannot continue to try this case, and have asked repeatedly to withdraw, and he's refused to allow them to withdraw as counsel. So there's if the counsel is not getting out on the basis of them literally losing their law offices, I doubt that he's going to let any of these jurors go.
It seems as if the judge believes that's defense counsel Caleb Bumpus, not defense counsel, witness counsel Caleb Bumpus, who is the one who is the leak. Based on the fact that he kept referring to she, and when we look at the order to show cause, she's the only woman outside of the DA's office who was in the room. So I have a feeling that that's what he suspects the leak is, and he's looking to come down on her hard. So if he's still on the case on June 25th, which I certainly will be streaming it if he is on the case on June 25th. But yes.
Also, how many alternates do you have to have? Because when you're talking about a 2-year trial, things happen. I mean, seriously, how many jurors are going to make it till
how
the
many
end?
alternates do they have? Do we know?
I knew at some point.
I just finished a 2-week trial. We pick and stack in Connecticut. You pick and then you come back a month later and try it. So we thought, all right, we better have 4 alternates. We lost 3 the first day. I'm like, yeah, at this rate, we'll get a mistrial, But unfortunately, everybody stayed healthy.
Wow.
It sounds dark there, Norm. Not going to kid you. When you say, unfortunately, everyone stayed healthy, that sounds kind of dark.
Well, you know what I mean. Hey, here's an audition for Saturday Night Live. An audition for Saturday Night Live. That's what this was.
Oh, you're going to show his testimony there where he's asked to identify?
This is my favorite.
This is his
rant. Anything you want to know?
Everything. The police kept coming to grab me. Every time they grabbed me, I had a different story for them. I know 100% facts, and I'm telling you now, I was not truthful. I was saying whatever they wanted me to say. I was saying whatever I could come up with. I was trying my best to convince them that I didn't do nothing, that I'm an innocent person, and that people put their hands on me. When they asked me about any of these things, you sitting here keep asking me step by step by step by step, and I'm telling you now because you asked me was I being truthful. Okay. I know I wasn't being truthful.
So is your testimony today that you lied in every interview that you did in 2015?
See, you the way you asked me that, I don't recall what I was saying in the interviews, but I'm telling you now, when they was questioning me 2015, 14, whenever they was questioning me, I was lying. I was making up stories. So when they were asking me about this right here, I was making it up. When they were asking me about this right here, I was making it up. And when they was getting me and they would let me go, I'm just telling you.
Do you recall telling every detective?
Every time they got me, I have told the police, I tell y'all whatever y'all want to hear, just let me go.
Do you recall every detective in every interview? You got to believe me. I'm telling y'all the truth.
Okay. This sounds like me.
Do you recall telling every detective?
No, let's do the white shoe.
Honest right now.
This case has
never believed something. I've never believed something more fervently in my life than he just testified truthfully.
Oh, absolutely. What about the other guy? This case also had the other guy who was like, I need some water.
That's him. That was him. That was him. It was the same guy when they asked him to identify. When they asked him to identify people, who was it, Stillwell in the room, and he's like, that guy, maybe that guy, maybe that guy.
Oh, the dreadlock.
The other one behind, the bald one. Nah, sitting behind. Who?
And he now has listening enhancement. He now has listening enhancement devices because he was pretending like he couldn't hear. So the judge gave him the enhancement earphones and was like, "So those enhance the audio so you can hear. We're accommodating your need for those devices."
I can't see. I got vision problems.
Eric, you ended that clip
why
early
did the
where he said,
prosecutor just stay on with the witness like that? I mean,
ridiculous. Danny made the point. Eric ended the clip too early. Listen, you got to play it a little bit.
There's this great clip where he goes, I said, I do not recall.
Well, that might be this
You
one.
can say it as slow as you want, but we're going to keep asking.
Let me see.
It never crossed my mind.
So how were you able to tell Detective Gaither that Nut and Thug was cool?
Because they're questioning me and I'm trying to get them off of me. And she asked me questions about Nut and Thug, I guess. And I'm telling her whatever she asked me. Let's say she asked me a question about the sky. I'm going to say, yeah, I seen the sky. It's blue. Whatever she asked me, I'm going to say, I'm going to agree to that. I'm going to say whatever she asked me. If she asked me about this reporter right here, I'm going to say, yep, she's sitting outside me with white tennis shoes on. I'm going to say something. Just because I want her to believe I'm telling the truth. That I want her to get me out of jail.
Well, she has on white tennis shoes, don't she?
Don't you got on white tennis shoes? She got on Chucks.
Right, and they white, right?
What color your shoes?
Oh my God, this is a disaster.
Can we hear that again? It's just,
What color
I
your shoes?
just need to go back. Can we go
She
back?
said they white.
Right, so you're telling the truth then.
I want her to get me out of jail.
Well, she has on white tennis shoes, don't she?
Don't you
my
got on white tennis
gosh.
shoes? She got on Chucks.
Right, and they white, right?
What color your shoes?
What was
She got on Chucks.
So you telling the
what are we
truth.
talking about?
What color your shoes is? She said they white.
So you're telling the truth.
Oh my
Are
God.
they tennis shoes?
And the judge
See,
is
you pick
thinking
what you
what
wanna tell 'em.
exactly?
Yes.
The district attorney. By the way, these district attorneys, they're so bad. They're
The
so
judge is so
bad.
bad.
Yeah, that's true. But the district attorney is so bad. They brought a motion saying stop upholding their objection leading, because basically we can't avoid leading questions. So we have to ask leading questions. So please stop. Occasionally you've been upholding their objections when they say objection leading. They filed this yesterday, a motion saying, hey, please, if they say objection leading, when we ask we ask very obviously leading questions, please don't say sustained. Please just overrule, because otherwise we'll never get through this trial. That's essentially what that motion is. It's a 2-page motion. It's hilarious. It's just utter incompetence.
Many years ago,
But the thing is, they need
prosecutor
Copeland.
dumped a 45-page motion on my desk before closing argument
Nice.
to limit what I could say. And I took a
Nice.
look at the first page of it, and I'm thinking, I'm not going to read this. So I tossed it in the garbage when the prosecutor's back was turned. A little bit later, the judge came out on the bench. The prosecutor said, I have a motion to be heard. I want, The judge looked at me and says, Mr. Pattis, have you had an opportunity to read that motion? I said, I have had an opportunity, Judge. And he said, what do you think I should do? Deny it. And that's what should have happened with that. Nobody should have read it. Just deny it,
Well, you know what? Since we're speaking of incompetence, should we shift to the Karen Reed trial?
We actually finally got
Sure.
a witness that made sense of something today.
What?
Sort
I'm
of.
so-
Although we got a weird camera view.
Yeah,
It's like this.
it was.
Or just for the-
So we finally got an answer from the prosecution to the Jen McCabe phone Googling how long to die in the cold, and the witness was great expert. I mean, phenomenal expert on data extraction of phones using any number of methodologies, and was able to kind of testify and present the conclusion that no, it was kind of as the prosecution aligned, is that when you open that tab, the only thing that's stored is the tab activity. And the search is what they were referring to as the search is actually the closing of the tab or some type of tab function. I'm not going to articulate it properly. But it was the first time when the prosecutor didn't look like he was stumbling over his feet. And that's because this witness testified at length and didn't let him ask any questions. It was great. Sorry.
No. Okay. Well, let's fill in a couple things. People were requesting before the show even started, they want to hear about Trooper Proctor.
Triple Proctor.
So who can tell me about the proctologist?
Dude, where do you even start with this guy? It's
With or
hard
without
to-
profanities.
Yeah. It's like I published a 4-minute clip yesterday where it's just basically nothing but profanities. It's like, well, might as well get those all out of the way in one big unmonetized video. But yeah, Trooper Proctor is the lead investigator, although he's just a secretary and he's not really that involved. And he as part of the investigation at the Alberts home, said he doesn't know the Alberts, although he seems to know the Alberts pretty well. They babysit his kids. He's soliciting gifts from them relating to the investigation to his wife, which sounds suspiciously like a bribe. He is upset that his fellow troopers didn't meet with the medical examiner to help guide her during her independent medical examination judgment so that she'd come to the correct conclusion as opposed to the incorrect conclusion that she did come to of undetermined. That was the wrong thing to do. And it was only because we didn't meet with her. That was she would have known better if we had helped to educate her. Also, there's just a lot of profanity and disrespect, and he's coming to very snap conclusions about everything. He's ready to call the case 18 hours into it, even though he says also he doesn't know what happened, but he's ready to say that Karen Reed did it. He's only talked to 3 witnesses, 2 of whom are the Alberts, the place where it happened, and 1 of whom is a McCabe, who's also closely related. He hasn't visited the crime scene, but he's sure that she did it, and also calling her the C word and the B word. But also she's hot, so she might leak poo. Does that cover everything?
Hold on. Is he the guy who wanted the nude pictures?
Yes, was looking through her phone for nudes.
Didn't find any nudes yet.
Didn't find any nudes. Apparently, it's very disappointing. Yeah, it's very disappointing. And she has a balloon knot and leaks poo, and that was the commentary he'd like to offer the court. And
you forgot his opinions of Unetti.
Yeah, she's an R word for her. Something.
Oh yes, that too. The R word for the client. I forgot that one. Sorry, missed one.
Oh, and also prayed for the unaliving of the
yes, that too.
That one.
Yeah, wish the defendant would off herself. That too. Yes, correct. It's hard to keep all these. It's hard to keep all these things in memory at the same time.
The best part is where the prosecution tries to draw the sting, and so they introduce the statement, and then defense just comes in and has him repeat the statement multiple times. It was brilliant. I loved it.
It was. If you have not watched That Day in Court and you need some day to just lift your spirits up, there is nothing that is better than seeing a defense attorney who is a master of the courtroom and a master of theater emphasizing and saying the hard C, hard T over and over again, and saying the F-bomb or dropping the F-bomb with enthusiasm that I have not heard in my lifetime as many times as you can. It's the best thing in the whole world.
Okay. Norm, what are your thoughts on your neighboring state case here?
I got to be honest with you. I haven't had a chance to follow it, so it sounds like I'm missing quite the show, so I'm going to let it go at that.
It was real. It was real. It went on for so long and it was so disturbing. And he's just flat out lying about things. He has no shame whatsoever. It's disturbing to watch happen. And even the judge, who seems to have, in my judgment, been unduly favoring the prosecution, seemed to be unable to do anything to save him. It was so bad. So
will he be continuing employment after this?
He's employed as we speak. He's still investigating cases. The state police have known about this for some time.
Remember that, ladies. Next time you get pulled over and they ask for your cell phone.
Yeah.
Okay. Well, didn't the paper the next day run an ad? The front page, it was the Boston Herald.
Yeah.
One of the newspapers, the front page was like misogynist now employed by state police. Like it was now seeking.
Yeah, pretty much. Yeah. Also, I forgot he was leaking operational details to his high school buddies in a text message that he still talks to. So not so much with I can't talk about the investigation as yes, I'd like to talk about the investigation in every possible way. Also talking about with his sister, who also seems to be very close relationships to the Alberts, who he then solicits for the gift for his wife relating to the investigation that he is himself pursuing. But he doesn't know them or have a relationship with them. He'd like to make that very clear.
By the way,
and they babysit his kids.
The behavior panel yesterday did a analysis on Karen Reed, which kind of surprised me. Apparently they were asked for it at CrimeCon, and the results are from an ABC interview she did. Apparently she's done one interview total, and their results were split. some of them think she did it. Some of them don't. It's an interesting interview if anybody wants to check that out. I just wanted to put that out there. The Behavior Panel, very, very large channel. Some friends of mine. Now, since they're split, though, I'm going to go to all of you who have been covering on the panel. Do you feel that Karen Read is not guilty and there's actually another crime that was covered up, or B, that the prosecution hasn't proven their case, or C, she definitely did it?
I'm with B. I'll let everybody else answer.
Yeah. At this point, the case is so weak that I doubt that there's proof beyond a reasonable doubt the Commonwealth exists.
Rob?
It's that bad.
That was a great take. That was such a good take. No, we know it was snowing though.
I want to be kind of clear on this because there's people on both sides of this aisle that are so strongly opinionated in both directions. I don't care whether she did it or not. I don't care whether there was a cover up or not. What I care about is the Commonwealth, whether it meets its burden of proof or not. And there is no way, based on what we have been presented, that they are at beyond a reasonable doubt. They have a couple more days left, but they haven't proven their case yet.
Okay. Interesting. Okay. What other cases were we talking about? Joe is sitting there back and muted. I didn't know if he has an update on his gag order case. And by the way, has that gag order been lifted on Trump?
Joe, come back.
No.
While we wait for Joe, I feel bad for Sarah Boone's attorney who can't get out of her service.
Dude, no, I don't feel bad for him. I don't, because he had to know. We're 8 attorneys in, and he didn't know danger warning sign. I have no pity on this guy. Apologize, my mistake. I have no pity on this woman. She got into this. She knew better. If I'm the judge, no, you can't withdraw. You are seeing this through. You are stuck to this case. You will see it through the end. You got into this thing.
I don't think she had much of a choice. I think they were running out of qualified attorneys to represent her. And she was basically next on the list. She's an extremely highly qualified, overqualified for this role. And for Sarah Boone to come in and say, I just want her to be nicer to me, was golden, really golden. So that's all I wanted to say about Sarah Boone.
Okay. Well, as long as they don't find an attorney in a suitcase, I guess we're okay.
Switching gears, Eric, have you guys followed up at all? Have you been following the Gina Carano Disney case at all? Or
I have not. I'd love to hear about it if you've got any.
Well, I mean, a few months back, of course, Gina Carano, who's the famous actress and I guess wrestler / I don't know.
Yeah, she has MMA.
Yeah. Filed a lawsuit against Disney for wrongful termination and other causes of action relating to her dismissal from the Mandalorian franchise that Disney had going on. And it was kind of a belated lawsuit. She got terminated or fired or whatever at least a year or so ago. But then she filed this lawsuit and basically said she was wrongfully terminated. She was treated differently based upon her sexual status or her gender status. A lot of different people in Disney who are employed as Disney actors had made some statements that could be construed as right-wing or at least as contrary to the message of Disney, and they weren't fired, but she put some out there expressing her beliefs, especially during the COVID time and later.
Her and Pedro Pascal actually both tweeted at the same time.
Correct.
On different opposite end of the spectrum viewpoints, if you will.
Yes.
And I think that there is a nice A to B hypocrisy angle there.
Exactly.
But, do you think it's going to actually matter or go anywhere, or can they just say sorry?
That's a really good point, Eric. I actually thought it did. I thought she had a good case. If you actually look at the complaint, it's amazing. It's just super well thought out. It looks like a trial brief ready to go to trial. However, we just had a ruling on Wednesday from the judge. Basically, there's a motion to dismiss based upon the First Amendment, Disney's First Amendment. Disney was saying, listen, we have a right to associate with whoever we want. There is such thing as we can fire for any cause we want. And in this situation, even if you assume that we fired her for her message on social media, we have a right to do that. Now, the judge actually denied the motion, but didn't deny the motion on the merits. Basically, just looked at it and said, "Listen, there's tribal issues of fact. There's been no discovery relating to this. I'm going to wait to you can bring your motion again, or I can do it sua sponte, and be able to, once I see some evidence, be able to make a decision." What was surprising to me about it was that I actually thought this case was one that might go to the court system, certainly to a motion for summary judgment. But it looks like, as some discovery takes place, that it may be a situation where the judge rules in favor of Disney, and this case kind of subtly goes away. This also garnered some attention because Elon Musk agreed to pay Gina Carano's attorney fees for this case.
So he's doing the Peter Thiel.
Yeah, I don't know if that's really true. I think this often happens a lot where he goes, "I'll pay for it," but I don't know if it really is happening. But regardless, there was some of that. There was some backing by his followers. So I guess the upshot on this one is that, this may go away quietly. I was quite surprised. I thought this was going to be a jury trial situation.
Hey, anybody want to weigh in on whether Alex Jones' social media accounts can be seized as part of this bankruptcy estate?
Ooh.
Wow. Yeah.
I would think so. Because
I think you can.
It's Free Speech Systems, right? Is the company, and if they are assets of the company, then they can be sold as just assets of the company.
How do you define social media accounts? The revenue generated by them, or the accounts themselves?
No, the account itself. Ian, these are fungible. These accounts are fungible. You see people that sell Twitter accounts, Instagram accounts, all kinds of stuff. There's a value to it. Now, it might not be what Alex Jones assesses the value at, but the trustee doesn't care, and the bankruptcy estate absolutely gets it. Sorry, bankruptcy practitioner.
$1,000 for the accounts. It sounds like a good win for me.
Well, I think what's interesting to me about it, I still represent Jones on appeal of those judgments in the state court. And know not a whit about bankruptcy law, but I talk to the bankruptcy lawyers from time to time, and about 1/10 of what they say sticks. Jones has his own personal bankruptcy. He's agreed to liquidate. There's a hearing today on Free Speech Systems petition, and I gather there'll be a liquidation order soon. And the Sandy Hook families have announced they want to seize these accounts. And I think bankruptcy counsel raised some claim that it was an untimely notice. I don't know, some claim. But, as I thought about this, it struck me that there's going to be a whack-a-mole problem, because today there's a real Alex Jones account on X with 2.5 million followers. They'll seize it today and do a public service announcement. Ding dong, the witch is dead. And then tomorrow there'll be real Alex Jones too. Do they go on and seize that? Or here's a different hypothesis, which I think is very real. Jones goes to work for one of us. And we employ him on a social media account we own to broadcast. What result there? Can they take?
Is he in an 11 or a 7?
I can't.
It started as 11. It's
been converted.
It's been converted to a 7.
Okay, so it's been converted. So that changes the analysis. If it was an 11, then his ongoing income is actually a fund to the bankruptcy estate. But the fact that it's a Chapter 7 means that you actually have a concrete date of when the estate exists. It's the date of conversion. The date of conversion, all of the assets that are in his hand that he has control over, essentially, imagine a trustee steps into the shoes of Alex Jones. And if Alex Jones has control over an LLC, an Instagram account, a corporate account, they can liquidate it as of that day and sell it off. But they receive that money. They don't get to continue going back to the new account or the new product or the new income. No, they get to sell it off in that day.
So
and
that ends it,
subject to conditions.
And so I think that ends everything, is what you're saying. That if he liquidates everything, he says, "I've given you everything I have." Does that mean that tomorrow he can start earning again and he's free, or how
he can start earning again? But keep in mind, the judgments that were entered, they are non-dischargeable, which means that there is no discharge in this case. The court will go through a liquidation, and what ends up happening at the end of this case is essentially the trustee will file a final account report and say, "We have marshaled all of the assets of the estate. We ask that there not be a discharge granted." Discharge gets denied, but at that point in time, the known world has basically seen that his finances have been diminished to the level where there's nothing else to get. Now you can keep going after it, but you have to do it via some state court mechanism. You can't put him back into an involuntary bankruptcy. That's already been done.
Is that like slavery? Almost?
I don't think it's involuntary. That's the question.
11 to a 7 is, and there's a reason why. When you convert from a Chapter 11 to a Chapter 7, a Chapter 11, you are the dip. You're the debtor in possession. So you're allowed to continue operating businesses to pay into this Chapter 11 plan, but most Chapter 11s end in a liquidation or Chapter 7. In a Chapter 7 case, when you get converted from an 11 to a 7, the question on the conversion, because at that point in time, the motion gets brought, either convert to a 7 or dismiss the case. And the question posed to the judge is, well, they're asking to dismiss the case, but the creditors get to chime in. And the creditors get to say, you cannot just dismiss this case. If you dismiss this case, what you're allowing the debtor to do, who has all of these debts, has demonstrated to be insolvent, you're allowing them to basically go back to the status quo and begin offloading assets and hiding them. You have to keep them in a 7, and you have to continue with the liquidation to at least satisfy what the plan would have been had they successfully reorganized in 11.
So once they reach that status, that it's the same as it would have been under 11. So in that case, this is why I'm so confused. Like, what's the advantage to having bankruptcy if it's non-dischargeable? Like, it's almost like I don't understand how that works, because if you have that drop dead date, and like you were referencing, that's fine. In that case, you can start to earn, especially when you're talking about a debtor like Alex Jones, who you can fully anticipate that if you totally divest him of all of his assets today, that a year from now he'll have more assets than all of us combined. So that's the question as far as, what happens with respect to, can they do this to him every 10 minutes? In which case, so at what point that when it's a non-dischargeable debt, like how does that work with him, with there being a bankruptcy and divestment of his assets, and yet it's not discharged? So now they can back here 6 months from now.
A lot of it is logistical. I mean, people don't want to be in a Chapter 7 post-conversion. Like, they don't like it. Most debtors will argue that that the case should be dismissed rather than converted. But when it gets converted to a 7, one of the benefits of maintaining and staying in that 7 is you've consolidated all the claims. So now you have the claims that are being essentially litigated for collection purposes in one place. And you have a trustee that's making a report and accounting of everything that's being done. So you don't have any of these arguments of, well, this asset was sold for less than market value, therefore we should go and get additional funds or be able to claw that back or say there was a fraudulent conveyance. You have one judge, one trustee, and one overseer that's essentially giving the bona fides to all of these sales and all of the distributions. So there is a benefit in the form of structure, and to the extent that another state court judge looks at the disposition of an asset that was liquidated in Chapter 7, and some state court, so let's say that someone tries to argue 5 years down the road that the sale of this social media account, that was fraudulent sale, they got less than what they should have gotten, and therefore we should be able to recover in addition to that. Well, they can't do that because this was done with the sign off of a bankruptcy court judge via the trustee, via the estate.
Well,
so
what value?
You're protecting the disposition.
What value does Alex Jones' a social media account have if he says, okay, you own it, I'm using another one?
2 million subscribers that they can convert to another revenue source.
Right.
It's not a lot.
How do you put a dollar value on that?
I actually looked into this yesterday. So I'll tell you that according to some sources I saw, they say that it can be valued as high as somewhere between $1.50 and $4 per follower, which is an astonishingly high number to me. I couldn't even believe that anyone would make such a claim that for every follower you have, that's worth $1.50. So his 2 million followers would be worth a minimum of like $4 million. That sounds insane to me. I also think that I would expect, and I'll ask you, Rob, this question. I would expect that with respect to this particular application, if I was a judge on this, I would want to have an evidentiary hearing and find out a few facts. First and foremost, is it actually transferable? Specifically, we're talking about his X account. X is very confusing with respect to their status as far as your right to sell your account. On the one hand, they actually have clear language saying you cannot sell an account, but the way that they tend to apply that is that they're really talking about what they refer to as squatters. Now, a squatter is someone who, let's say, would say, oh, okay, I'm going to grab the name Law and Lumber before Rob can get it, and then I'm going to try and extort Rob to get him to pay me to get that Twitter handle. So that's something that Twitter clearly is strongly opposed to, as opposed to someone who actually has an account that's viable and is functioning. They're actually using it the way each of us and Alex Jones are using our respective accounts. That if you want to sell that, someone who buys it can actually take it, that name, real Alex Jones, and they likely would change it to something new, and you still have all the same followers there. So now, if you're some gaming company, you're Beatrice Foods, whatever it is, you can be Macy's. You can now rename it to something that you want, and all of a sudden, you have 2 million followers who are getting your updates about sales or different promotions you want to have for whatever it is you want to promote. Now, one would expect that if I was a judge, I'd be very curious to hear what would be the anticipated fall off of that. What is the market value with the anticipation that the second that's changed from real Alex Jones to Nintendo or whatever, that there would be a fall off, that people would stop subscribing, right? I mean, you would imagine at least a third of them, most people would have apathy and not even notice it, but at least a third of the people would probably say, I'm not following this account anymore. So the sale would not actually be for the same amount of product. And it's a real, I would be very curious as to the valuation, because at the end of the day, this is certainly affecting his freedom of speech. He still has freedom of speech. He could start a new account on X. It's not like he's prevented from doing that, but it does seem like it's having an impact on his freedom of speech. And I would want to know that's my own personal take without researching the law on this. If any of you know law on this, I'd be really curious about it, or even just your philosophical takes on it. That if it's something that they would be able to net out as something like $50,000, I would say that's too insignificant to affect his freedom of speech to this degree, because he has far, far more utility out of it himself personally than the debtors could translate into a fungible asset. But if it's something that theoretically they could actually sell and make $1 million from, in that case, I'd be like, look, you know what? I understand it's affecting his freedom of speech, but at the end of the day, he is a debtor. This is an asset. He still has freedom of speech. So he can start a new account. And in that scenario,
I think that's where it begins, Joe. I think that's where it begins and ends, regardless of the value. I don't see the court balancing here.
No, there's no balancing. There's either an exemption, there's not. It's not an exempt asset. You don't have an exemption for that asset. It's an asset. It gets sold. But what you highlighted as far as the valuation is interesting, because that actually was going to the point that I was saying about the benefit that Alex Jones gets. You were saying that some people were valuing it as high as $3 or $4 million. Well, let's say that he were in a private setting to sell that account for $100,000. Now you have a fraudulent conveyance action against him, seeking a judgment of the difference between that $3 million estimate and the $100,000 he sold it for. In the bankruptcy context, the value is what the trustee can get for it. That's what it is. Right. The trustee goes out and markets the sale and comes back to the estate with a contract. And the contract has an actual dollar figure, and the bankruptcy court reviews it and says, based on the evidence presented, yes, this is a fair valuation, this is a fair transaction, and it is more benefit to the estate than not selling it. We're going to go ahead and approve the sale. That's the benefit of the bankruptcy liquidation process.
By the way, I got to tell you guys.
So doesn't it benefit him to overvalue that asset then? Because he knows that as soon as he sells it, all of his followers are just going to follow him to his next setup, wherever that might be. I mean, how does the judge craft it so broadly to follow him wherever he goes?
Also, by the way, if Joe's scenario, somebody buys the real Alex Jones account and makes it the Bill Smith account with 2 million followers, Alex Jones can create the real Alex Jones account immediately. As soon as that name becomes available, he can jump right back in and then be the real Alex Jones starting at 0. He'll get to 2 million in no time, probably get to 4 million.
Here's my prediction, and I don't know this, but I wouldn't be surprised if Alex affiliates with Tucker Carlson and branches out there, and that Tucker owns, the next portal. And good luck with judgment creditors pursuing him along the way. But who knows?
Why would that? Why would that make it more difficult? Can you clarify that, Norm? Why would that make it more difficult for creditors to come after him?
He's an employee.
He's an employee. I'm told that at least, and I don't know bankruptcy from beans, but I'm told that in some states, if you're paid by way of an annuity, that's not reachable by bankruptcy court. So suddenly you've got a third party host that is that owns your portal, and he's paying you by way of an annuity. Therefore, you're earning whatever you're earning, doing whatever you're doing, and Now then the challenge becomes upon liquidation of the the annuity. What are you purchasing? What do you got? And I think the judgment creditors continue to watch there. But I expect a game of whack-a-mole for 15, 20 years as against Jones.
It's gotta be the smart. I don't want to. Let me think. Smart way of doing this would essentially be compensation by some trust agreement where I create a revocable trust and I don't pay you a single dollar, but the benefit that you receive as being my employee is that you're the named beneficiary of this trust. What the trust does, the trust then pays out directly for your lifestyle. It pays to an apartment that's in the name of the trust. Yep. It pays to a vehicle that's in the name of the trust. It pays to these things that are
your food, everything.
Trust that you have beneficial use of for so long that you're an employee. There's nothing to go
He
after.
already has this. I mean, guys, you got to remember, this guy's super advanced. He already got irrevocable trusts all over the place. He has offshore corporations. He's not hurting for money. You just have to understand this. This is actually just a ploy. I mean, first of all, there's no market value to his accounts. X would step in right away. And if real Alex Jones became Macy's, it would absolutely say it's a violation of terms of service. I've been doing this for a long time. Social media platforms outlaw outright any selling of accounts. It happens all the time. You're right. But the bottom line is it's wrong. So they, with Elon respecting Alex Jones, they would probably intervene if there was a problem. So
that was the question I had.
What he'll do is, and he won't be affiliated with Tucker. Tucker wants nothing to do with Alex Jones. I know they're friends and the whole thing, but he does not want the attention and the hotlight Alex Jones provides. He'll just do what he's going to do. He's going to say, listen, I'm the victim. I've been slammed by the federal government. They've taken away my accounts. That's why I need your help. And also, that's why you need some supplements too. And what do you
actually, if you're interested in the media landscape, there are some shifts going around on the right, and some dark horse people you should watch out for are Patrick Bet-David. Very well may jump in, and he would pick up Alex Jones in a heartbeat, I believe. And then Elon Musk himself may just go ahead and do it because he already let him back on X. The show's performing well. The spaces, et cetera, are doing extremely well. And Elon's been quietly trying to build his own network. But yeah, don't rule out Patrick Bet-David. That guy's been very much on the side.
And this is what's happening a lot in general with business is businesses are going offshore. That's part of my business now is that, you think about a lot of the crypto billionaires and all their schemes. They're in the Bahamas. They're in the Cook Islands. They're all over the place. And Patrick Bet, I wouldn't discount him, but I bet it's by virtue of a Puerto Rican entity or something similar that can't be reached. Yeah.
I mean, the guy built his fortune on MLM, so I'm sure that he could figure out a way.
Yeah, I'll tell you, I think I was thinking, and this is something I brought up last night also, what Ian's talking about, the X factor, literally and figuratively, of Elon Musk, where he's able to, where if he would just throw out a tweet saying, if Alex Jones' account is sold, I am not allowing, we will shut that account down. That turns that asset into $0 because how can anyone buy it? If you buy it from him, you know it's going to be shut down 10 seconds later. So it literally ends up having no value to anyone but Alex Jones. And that would actually spare, I think, Alex Jones from having to go through the ordeal of restarting a new account and having to go through that. And it's in Elon's interest to do that. And he also has the rules on the books, the unenforced rules on the books that say you're not allowed to sell. So even though he never really enforces it, in fact, there were actually websites out there that enable you that will sell it for you, which is astonishing. That if you meet certain criteria, they'll sell your account for you. You have to have 50,000 followers and all sorts of other things, but that they'll sell your account for you. If Elon were to say this is this account we are going to enforce and not allow it to be sold, I think he has enough verbiage in his terms of service to stand behind it as not a special rule for Alex, while at the same time protecting Alex from having this thing sold off from underneath him.
Could be.
Don't mistake the point. Don't mistake the point. If there's a dollar figure in it for the bankruptcy estate, and I mean that even if you have someone who says, I will buy that account for $50,000 just to take that name and take it off the market, the bankruptcy judge, if that can be a marketed transaction, if there's any IP rights there, the bankruptcy judge can and will sign off on that for the simple fact that $50,000 comes into the estate.
I gotta say, guys, there's a great comment by Rob here. It says Alex does not own his X account. X owns his X account.
There it is. And that's the question too, because Elon Musk, I mean, literally, he could just say, no, tough shit. And even if somebody did buy that account to keep him away from it, there are actors who have bought and managed to get their name or other people's name. There's a thing called domain squatting. That, in essence, is what you're describing, Rob, is a domain squatting. And even that can be overcome. If you could prove that somebody has bought just a name just for the purpose of blocking somebody else from getting it, a lot of times you can get around it. And Elon makes the rules. It's his company. You could just literally say, boop, bye-bye.
On the back end, that's all well and good. All I'm saying is I can see a bankruptcy court signing off on it. So you can jump through those hurdles later.
Good, let them overvalue it.
Yeah.
That's what I say.
And that would actually be kind of an interesting situation. Let's say they did do that, they accepted it, and then Elon spanks it, and then Alex gets his account back.
Yep.
Yeah, that literally could happen.
Yeah. Oh, that's feasible.
And I'm just curious, what do you guys think would be the right thing? I have problems with identities being sold off. You know, it's like if we can at least have our name and our voice, I think it's kind of going a step far where he can't talk as himself any longer. He has no rights to his own identity. That just seems draconian, but I'd love to get your
and like the entire point of this.
Yeah, I think that's right. That's always been my position. The goal in this case was not money, but to silence Alex Jones and to build a Senate campaign. Stay tuned for the Richard when Blumenthal retires in 5.5 years. I predict one of the trial lawyers from, and I know which one it is, from the Sandy Hook litigation team is going to seek his Blumenthal's seat, and he may purchase the real Alex Jones account just to say, I stopped the real Alex Jones. Send money, you know.
Ugh, I hate politics.
I have.
Hey, Joe, can I ask you a question? What are you glad you did the whole Trump thing? I haven't had a chance to talk to you since.
Yeah. I actually, my attorney, we're supposed to be filing the Court of Appeals. My attorney has been very, very swamped with respect to that. I ended up bringing attorneys to represent Good Logic LLC, but it's been very, very exhausting, and the process is still ongoing, and I'm still hoping to get to the Supreme Court. We're supposed to be filing next week the application to the Court of Appeals, which between you and me, if the Court of Appeals turns us down, it only expedites things a little bit faster for us to try to get into the Supreme Court. But my lawyer is very confident. He's quietly confident, as confident as you can be, that this is exactly the sort of case that the Supreme Court grants cert on, and it checks a lot of bells and whistles for what they tend to be looking for. It's a First Amendment case. There's a circuit split here on a pivotal issue as to whether or not the state or the court is able to apply fair administration of justice against the defendant and use it as a weapon against the defendant. And there certainly seems to be a circuit split between the Sixth Circuit and the DC Circuit Court as to whether or not that's allowable. So there's a lot of reasons that, I mean, the reason they would not take it is because I think they want to avoid weighing in on Trump wherever they can. And this is, certainly Trump, very much Trump related, even though my whole argument is that this is not about Donald Trump. It's not about me. This is about the rights of defendants not to be wrongfully silenced. But it's going to be spun in the media as being all about Trump, obviously. So, he's hopeful that they will grant cert, and there's good reasons to think that maybe they will. So, that's where we're at. But as far as your question, this was a very, it was a rare opportunity to actually feel as if I'm doing something rather than talking about doing something. Mm-hmm. So, I feel like this is something that, would be, even if it doesn't end up succeeding at the end of the day, just going through you were correct in what you said when you were pushing me to go forward with this, is that at the end of the day, just making the effort, I just feel as if look, I'm fighting this fight as hard as I can, and whatever comes of it, at least I'll be able to look, my kids and grandkids in the eye and say, look, I fought for what I believed in, as opposed to just sitting there chirping about it.
Yeah. Great point. Well, to wrap things up, I know people have appointments, things to get to. Ian, please tell us what you have coming up.
Well, I'm just enjoying my tenure on X and YouTube, just explaining kind of important legal issues that are out there. So I kind of bounce between California and Arizona a lot, so I don't have a tremendous amount of time to do live streams and things like that. But I just love making short form videos, so that's what I do on TikTok, Instagram, X, YouTube, all the social media platforms.
All right, and Norm, what's happening with you?
So Mike Boyer and I continue to stumble along at LawPod Daily. Our topic is law and legitimacy, trying to create a civil discussion about the things that divide us most. We, unlike the rest of the luminaries on this show, are but a small shop. So like us today, get us over 2,000, and Mike will be thrilled. I hope you'll listen in.
There's a link in the description, by the way, for all the channels, except for mine. I think I forgot that. But anyway, all the channels, please go and hit that. And while you're subscribing to everybody, you can always subscribe to this one. Appreciate it. And bringing them together. And then that leads into Joe, Good Logic. And by the way, I've kind of stopped doing the cutoff thing at the end. It was a fun gag, ran for a while, but we'll actually let
it ran its course.
Joe get his comments out, period. But Joe's almost to 100,000. So when we're talking about thresholds here,
it's like 1,000. You got to go there and subscribe, people. I mean, you got to get them across the threshold, man.
There's enough people here, if you're not subscribed, to take them over right now.
Right now.
You should click it right now. Click it right now. Go hit that subscribe button. Do it. You know you want to.
Yeah.
Definitely. Check out Joe. He's doing good work. He's out there fighting. So what do you have coming up?
Well, I'm all over this Judge Glanville thing. And I was very pleased to see that his order show cause return date is June 25th, which happens to be my birthday. So it's like a nice little birthday present for me that I get to stream Judge Glanville losing it in order show cause of the most bizarre nature imaginable. So, yeah, but I certainly plan on being all over that. And also I plan on having updates soon with my efforts to ungag Trump. If you want to learn more about that, you can check it out at givesendgo.com/ungag Trump. And I know that is where people can come to contribute to it, but there are links there to the filings that I made and a whole explanation as to what the lawsuit is about. If you're still unfamiliar with it and you'd like to learn more about it. So there you go.
What do you have going on?
Yeah. Well, we're doing a lot of Karen Reed coverage lately, which has been very enjoyed by a lot of people. So I'm really very thrilled that people like it. We're just doing these shorter excerpts, trying to get it around 10 minutes, where we just cut things up. And boy, do I have a lot of editing to go through for Karen Reed with respect to Proctor. Post a couple videos already. I think the last one I posted in particular was perhaps the most disturbing, because it just really went through his conflicts, the less salacious with the profanity and the misogyny, and just more of the direct corruption, the direct relationship to the Alberts, the direct solicitation of the gifts, the direct leaps to judgment, the fact that he interviewed 3 people, 2 of whom are all the Alberts, didn't visit the crime scene, doesn't know what happens, but already did draw the conclusion Karen Reed did it 16 hours into his investigation, and it just goes on and on and on. So I managed to trim that down to a 10-minute segment. So I'd recommend people check that out if you want to see what's going on. And we've got a lot more to cover, because he was just a endless resource of horrible, and it needs to be exposed.
Question: have you thought about putting together? It would be really helpful, like for people like me, just like a timeline of here's the Karen Reed case, here's where it's going to trial, and here's where we are so far. Just kind of like a timeline of events and things that I could point people to, and other people could point people to. Like, if you want to know what the hell's going on with this case,
that'd be amazing.
Check out this video.
Karen Reed for beginners.
Yeah, Karen Reed. I love that. Karen Reed for
I'll try to put something together this weekekend and maybe have it for Monday. How about that?
That would be
cool,
great.
That would be awesome. Seriously,
I'd personally check that out, because I feel as if every time, I don't know if you noticed, when the Karen Reed topic came up, I actually was like, all right, 10-minute break for me here.
Yeah, man.
I'm like, I'm out of here. But if I actually had that, I feel.
I am constantly every day gobsmacked, although Proctor might be the end of this road, but every single day up to Proctor. And Proctor was 5 weeks into this trial. And every single day I was just more and more gobsmacked, more and more amazed that somehow we had reached a new level of low, because it's just got worse and worse and worse every single day. And I am aghast that this case has been brought to trial by the prosecutor. It is a shameful indictment on the prosecutor's office that they went forward with this absolute trash fire.
It's funny.
And they should be ashamed of themselves. They're supposed to know better.
Well,
consider the source. All right, Danny, what do you have coming up?
Well, now you're going to make me sound like a liar, but I swear in the chat, I told everybody in the chat that I am doing an entire breakdown of the case and a summary of the case up to today. So,
cool.
If you want to do that too, go ahead. But
no, have two of them. That'd be great.
Beyond that,
or do one together. That would be cool.
Guys.
I don't know.
Because you guys probably have read through YouTube's terms of service more recently than I have. I want to bring on an attorney to talk about his challenge of the PrEP Act. There is a case coming out of Utah challenging the liability of the vaccines and their use on patients and whether or not you can actually sue. And so he's challenging the PrEP Act, which provides some protection there. I would like to have him on the show to discuss that, to discuss the rollout and why his challenge, I think, will ultimately get to the Supreme Court and has a very good chance of being successful. Do you guys think that YouTube will strike me for that? And will I lose my livelihood over it?
You've got to be, it is so touchy where they've taken back and say, no. But I would recommend, saying things like the coof and just, I hate to say it, sound like a drug dealer who's, doing a transaction and using code words for everything you're saying. That would be the proper template. So things like the coof or the beer bug or, whatever.
Virus that can't be named, all of those things.
Medications,
Kung flu.
Kung flu, forced medications, things like that. And it just
medical
really,
experiments.
I recommend just being vague as possible. Sort of like on AUS, I cannot say the S word. And it's the S word that has a side on the end. But for some reason, that channel and that word, when we use it, the videos that's only get typical. Demonetized, but they actually get adult only.
Oh, that's hardcore. That's hardcore.
So that's something that I worked on during COVID, actually, and it's something that I worked on when I worked at the county, and so it's something I'm passionate about. I would like to have this attorney come in and speak, and so that's hopefully going to be coming up on my channel.
Danny, are you contemplating doing that live or in video form?
That's the
video form would be better.
I think video form might be better so I can bleep things and edit.
I wanted to bring up, with all due respect, because I know we're on multiple platforms right now. YT is not the future of social media communication. I know everyone talks about it and things like that, but it's really not. Behind the scenes, it's not. Really, X Live right now is amazing. You have a great amount of reach, even a smaller account. So I don't know. I know what you're saying as far as live on YouTube is could be shut off at any time. But if I were starting again, I would be all in on X right now because you're able.
And you don't necessarily have to choose.
You don't have to choose. I do it on StreamYard.
You have to choose, but you have to choose where you put your emphasis. And if you're really worried about continuing on with this YouTube audience situation, then you're going to have to start speaking like a weirdo. And then what ends up happening is people start saying, one, why are you speaking that way? And then two, maybe challenging you, saying, dude, are you really bowing down? So I guess what I'm trying to say is over time, maybe focusing on things that have a little more freedom might be the best thing. And right now, a lot of us are getting paid by X. I mean, it's pretty awesome.
That's the thing. I'm not either. And the monetization on X is tough. So,
I'm not either. And I have 48,000 followers, and I'm not getting paid. I can't get approved by them to get paid. I applied literally 2 years ago.
Wow.
Hold on. Did you?
I think I have to get a certain number of engagement. I am paying. Yeah, I'm.
You're Twitter Blue. Okay. No, I was gonna say you need 5 million. 5 million impressions over the last 3 months. So if you go into your account, go under analytics and then click monetization, they'll tell, go in analytics. You can see how many people.
I don't have enough impressions over 3 months.
Right.
That's because you have 5 million user. And then the other part too is I think live is a great opportunity. Danny, when you go live on your streams, I always see it on X. There's always. they're putting it right up front. So I guess I'm trying to do is just give you an opening too, because with all due respect, having been on YT for a long time, I'm not putting my eggs in that basket.
Okay. And maybe that's where we do it. So go ahead and follow me on X too. Danny on Direct. That's where I'm at.
So. Yeah, she's great.
Oh, thank you, Ian. That's very kind.
And on that note, we'll follow everybody on X, by the way. I'd like to get up to my numbers. Joe, of course, is the following.
Subscribe to Joe. Can't get the finger point the other way. Subscribe to Joe. He deserves it.
Thank you.
Sounds good. All right. See everybody next week. And